So thank you everyone for joining us today. Our topic today is it time to update your estate plan? And my guest is Adam Bartsch. Adam is an estate planning attorney who operates Northeast Estates and Trusts in Shelburne. And Adam has been our guest before. Adam is one of the attorneys that we trust to refer clients to, and Adam does fantastic work and is certainly an expert in the area of estate planning. By the way, my name is Michael Thompson. I'm the partner and senior wealth advisor here at Copperleaf Financial, based in Williston, Vermont, and we'll carry on. So, Adam, thank you for joining us today. I'm looking forward to our conversation about is it time to update the estate plan, because lots of people we talk to haven't gotten their estate planning together. It's been a long time and they procrastinated putting it together or speaking with an attorney and getting even a basic will together. But other clients have an estate plan, but it's been years since they updated it. So let's talk about when is a good time to update the estate plan, and what's your thinking at sort of a basic level? When should someone think about updating their estate plan?
Well, thank you, Michael, for having me. I appreciate it, and I appreciate the introduction. It's hard to say. Usually there's some type of life event that happens. Either a life event or the reason most people come back to me for updating their plan is because they want to swap out one person and swap in a different person. And that might be the executor or the trustee. Or it might be, circumstances have changed. They started with a will maybe 10, 15 years ago. The children are grown up. And now there's a reason to have a trust-based plan in lieu of a will-based plan. So there's a whole slew of reasons. But the most common is people. Someone who maybe they named as the guardian of their children is no longer the right person to take on that role. And that's an important issue. So people want to get that done fairly quickly, just in case.
And you raise a really important point, which I try to remind people of, which is a lot of times, hopefully, when people have younger children, they've gotten a basic estate plan in place, so to provide for guardianship and for management of assets in the case that mom and dad are gone. But kids grow up and they leave the home and they take on their own responsibilities. And as those things change and they change, it's really important to update the estate plan. I mean, what happens if someone has an old estate plan and they provide for guardianship? I suppose the consequences are probably minor, but gee, that seems like there are other considerations when kids grow up and become adults and maybe they're responsible and are able to handle things and take on roles within mom and dad's estate, but maybe not, right?
Yeah, I mean, strictly speaking, guardianship only lasts until the children turn 18. So that's a diminishing issue, and over time it simply goes away. But there are other reasons. I mean, kids grow up. Number one, once they head off to college or head off to adulthood, so to speak, when they turn 18, one of the things they need is their own HIPAA release.
Yes.
HIPAA authorizes the parents to have access to the child's medical information. And unfortunately, too often kids go away and no one has really access to their medical information should they end up in the hospital.
Yeah.
And usually things get worked out, but it can be some very stressful days before the parents can convince the hospital to talk to them. So that's an example of kids growing up and one of the things you ought to do. Like you said, other circumstances change. The sad fact is people look at estate planning as a one and done type of transactional thing. It's been on their priority list. They thought about getting it done. They did it, and then they take it off their list and they don't come back to it until something terrible happens. That's not the best approach. You should review your plan every 3, 4, 5 years, because things do change, and what you wanted 20 years ago is very well, very possibly not what you would like to have done now.
Yeah. Let's, I want to remind people just a little bit of housekeeping. Any questions, if you have questions, go ahead and submit your questions. You can submit them in the chat box at the bottom, and we'll pick up your questions as we go. And also, as a reminder, we record these sessions, so this is being recorded, and if you have friends or others that you'd like to share it with after the fact, we will post this recording on our Copperleaf website sometime next week, early in the week next week, so you can look for it there. And you can also see previous town halls, including one I did last year with Adam around basic estate planning, or the basics of estate planning. Other changes in you talked about people, and you talked about maybe a need to change an executor or a trustee. What are considerations there, and what are some examples, Adam, that you see of people's need to adjust those folks that are named in roles of responsibility within the estate plan? How should people be thinking about that?
Most frequently, it's simply, you've named a trustee or an executor, and maybe you've lost connection with that person. You've either lost connection, or you're not as close as you used to be. Mm-hmm. And maybe someone else is better suited to be that person. Or it could be, even worse. It could be the person dies and they're simply not available, and you're questioning who you've named as the backup. It can be personality driven. It can be family driven. It can be, again, something more severe. Trustees, you're putting it's a big, not a big responsibility. It's sizable, but you need the right person. When it comes to your executor, you want a person who's going to be patient, who's going to be practical, who's not going to make rash decisions, and they have to be someone you trust to do the right thing. And over time, the perfect person 5, 8, 10 years ago, might have taken a different path in life, and they're simply not the best person anymore. And that's the type, I looked at my numbers earlier, and 1 out of 7 of my clients in a given year comes back to update their plan. Huh. Not to overhaul it necessarily, but to fix something here or there.
Yep.
So that's 14% of my clients are coming back in a given year to fix it, which I thought was kind of high, but things change. Some people come back every year, believe it or not. I'm doing updates for some people once every 1 or 2 years. Mm-hmm. Other people, I do the plan and I never hear from them again. So yep. It spans the whole thing. But it's certainly appropriate. It might not, if circumstances change that frequently, updating annually could make sense, but certainly every 3 or 4 years, as you said, makes sense, because even if there aren't people changes, there may be certainly circumstantial changes that are important to pay attention to. For example, one's net worth could change, one's financial position could change significantly over a period of time. And that's absolutely a time or an event that would make it important to update the estate plan, because there may be, what the estate plan that we created 5 or 10 or 20 years ago may not have taken into account my current financial situation. And that might be a whole new set of circumstances that we need to address in terms of how assets are distributed or managed in the future. What are can you think of any examples, or how do you think about that in terms of change of circumstance from a financial perspective? Well, that does happen, and sometimes it's anticipated, and sometimes it's not. Sometimes people are in business, and the business just takes off, and what they have, what I did for them 6 or 8 years ago is no longer sufficient. For example, mm-hmm. They might have had a will-based plan because they were younger, they had young children, and they just kind of wanted to cover the bases.
Mhm.
But now business is done phenomenally well, and they're going to have a tax issue. If they don't plan ahead, they're going to have a sizable estate tax problem. And to handle that, they need more advanced planning.
Yeah.
Another example, I'll have clients in who know that they're going to inherit a good chunk of money
Mhm.
at some point. But that point could be, next year or 20, 25 years from now.
Mhm.
So what we sometimes do is we do just a basic plan because, they haven't inherited yet. They don't have a lot of assets. They're probably not going to make a lot on their own. So we're going to cover the bases and make sure they're covered with guardianship for the children, all that sort of thing.
Mhm.
And then when the inheritance is either creeping up close or it happens, then we jump into the next category of estate planning, which is typically a trust-based plan.
Mhm.
Historically, it's been for tax reasons, but there's other good reasons too. Supposing the family has divorced and they've remarried, and now it's a blended family.
Yes.
Blended family is a good reason to have a trust-based plan, simply because there's something called unintentional disinheritance,
Mhm.
where the surviving spouse gets along great with the spouse's children from outside the marriage, but even if they get along great now, 10 years down the road, they very well might not. So you want to protect your children and not have them, disinherited by the surviving spouse, even if the relationship is fantastic right now.
Yeah. And that's such a good point, Adam, because and what that means to me is it's so important, I think, for people to work with somebody like yourself who focuses your practice on estate planning and takes the time to listen and ask good questions and understand the client's situation to make sure that you help in a collaborative way build an estate plan that really is designed for that client's unique situation. I've seen so many sort of boilerplate estate plans that do exactly what you say, end up unintentionally disinheriting a spouse from a second marriage or creating potential problems with other beneficiaries or family members. And it really takes somebody who understands the law as you do, understands the nuances of estate planning, doesn't do it on a casual or a part-time basis in addition to their real estate practice, but really hears what's going on with the clients and helps address those issues. So anyway, I just wanted to acknowledge and thank you for doing that on behalf of your clients and ours that we refer your way. That's so important.
Yeah, no question. The specialization in the legal field has accelerated, much like the medical field. You might go to your family practitioner to diagnose an issue, but once you find the issue at hand, then you're typically pointed to someone who really looks at that, issue almost day in and day out.
Yeah.
And my advice for attorneys, if you're looking for an attorney, you don't have to find one who only does estate planning, but you should find someone who does estate planning at least 50% of their time.
Mm-hmm.
It's just important because, the old saying, you don't know what you don't know.
Yes.
It applies here particularly because a lot of bad things can happen and you don't even know what's going on. But when these things come to light, it's too late.
Yeah.
And then, your family's spending money trying to untangle a mess that was easily avoidable. So I believe in specialization. I practice it, and I encourage others like your clients who come to you to find a professional who knows what they're doing to handle their money. It's just, it's the way life is today.
Yep. Let's talk about some of the exogenous changes that may affect or maybe a good reason to update an estate plan. For example, the most obvious in Vermont is, we now have an updated estate tax threshold in Vermont that's very different than what it was 10 or more years ago. Can you talk a little bit about what the estate tax exemption is in Vermont now, and And how has that changed, and how should people be thinking about that if they need to update their estate plan just based on the Vermont exemption?
So I would say there's good news and bad news in this respect. The good news is the exemption increased pretty radically over the past few years, over the past 6 or 8 years. It went up from, I think, 2.75. It's now 5 million per person. And 5 million per person, is the vast majority of us.
Mm-hmm.
But there are people above that. The nice thing in Vermont is it's per person. So as a couple can preserve 10 million if they plan ahead. Now on the federal side, it's even more generous. It's 12.9 million per person. So that's the good news. The not so good news is that a lot of planning was done when the threshold is much lower.
Mm-hmm.
And if you have a trust-based plan, it might have a formula in there for what happens after the death of the first spouse. And that formula might be based on a really low threshold for the estate tax, which can complicate things in today's world. Because we have a high threshold, we can be a lot more flexible. But if we're locked into a rigid formula that says a certain amount must go to the credit shelter, or a certain amount must go to the family trust or the marital trust, that can needlessly cause problems. So I guess my advice is, if you have an older trust, anything predating 2010, probably ought to be looked at, because you want to avoid these inflexible formula clauses that mandate an unnecessary rigidity in the plan that simply is not needed given today's high exemptions.
And talk about that a little bit more, because sometimes I think we talk in generalities that might kind of go over people's heads. But can you give any specific examples of how an older structure in an estate plan, when the exemptions were lower, could lead to problems? What kind of problems might that lead to today?
Well, there might be a mandatory creation of what's called a credit shelter trust, mm-hmm. which can be the decedent's trust. The way this typically works is, in a couple-based plan, you can have either a joint trust or separate trusts at the outset. Upon the death of one spouse, you often have what's called a credit shelter trust, which is just what it sounds like. It shelters the credit, the exemption of the decedent. Now that's important, because each person in Vermont has an exemption, but if you don't plan for it, you're going to lose one when the first spouse dies. The downside is, when the credit shelter is created, the language might be put the minimum amount necessary into what's called a marital trust and put everything else into the credit shelter. Now, that's not the end of the world, but it's a hassle, because then the surviving spouse has two trusts to worry about. They have their own trust, the survivor's trust, and they have the credit shelter trust. What I do a lot these days is what's called disclaimer planning, giving the surviving spouse the option to either create the credit shelter or have just one trust that they're managing after the death of the first spouse, the survivor's trust. And again, it's not a huge deal, but managing one trust is simply easier than managing two trusts.
Yeah.
And it gives the surviving spouse a lot more confidence that they have access to all of the combined estate. So they're not going to be hindered when they're trying to live their life out. They're not going to be hindered by restrictions on accessing what's in the credit shelter trust.
Yeah. And how does that work if there's just one trust and we still want to preserve the spouse, the credit from the spouse who's passed away, the decedent? How does that work exactly if we don't have a credit shelter trust?
Well, it really, honestly, it doesn't work. But let's say we have a $3 million estate.
Yeah.
And back when the Vermont threshold was 2 or 2.5, credit shelter planning was important, because you needed something to go into the credit shelter, but now you don't need both trusts because the exemption's $5 million.
Yep.
And if the surviving spouse ends up with the entire estate, $3 million, that's okay.
Yep.
Provided they don't get remarried and send it all sideways instead of going down to the children.
Right.
So keep an eye out for the pool boy is what I'm saying.
Exactly. Let's talk, since we're on the topic of estate taxes, let's talk about the federal issue. And as you said, the exemption is pretty high now, 12.9 million per individual. But that's due to sunset at some point in the not too distant future, right? And so what's going to happen then? And I know you don't have a crystal ball, but who knows what's going to happen with what Congress will do or not do. But chances, there's at least a coin toss that they'll do nothing. And if they do nothing, where does that leave us?
So let me give you just a little bit of background history on the estate tax, not going too far back, but as far back as 2010. In 2010, the federal exemption amount was set at $5 million per person, and that was indexed for inflation. And that came up over the years, and in 2019, they doubled it, but only for seven or 8 years. So that doubling led us to where we're at right now, which is 12.9 million. Mm-hmm. So it's really 6.45 doubled. But the doubling goes away in 2026. So in 2026, we revert to not the doubled amount, but just the regular 10 million plus inflation. Mm-hmm. We think that's going to be about 7 million per person, plus or minus. Mm-hmm. Now, again, this is not an issue for most of us, but for those who are worth more than 7 million, it behooves you to plan ahead, because if you don't, you're going to pay estate tax. And on the federal side, estate tax is 40% of the amount over the exemption.
Yeah.
So that's a big deal. And then you tack on the Vermont tax on top of that. You're talking about 48 to 50% of every dollar above the federal exemption amount.
Which is a big deal. And you're right. That's not most folks, but for people that are in that category, that's a lot. That's a lot to have the estate taxed at nearly 50% is a big deal. Are there steps that people that are in that category, and maybe people on the call today, or maybe they know people that may be in that category, are there steps that people should be thinking about taking if their estate is kind of breaching that level, that could take advantage of the way the law is today in the event that it sunsets in 2026 and goes back to the old way? What should people be doing?
So the good news is you don't have to act immediately, but you probably want to do something before 2026. And what you can do, let me give you just another thumbnail sketch. The exemption can be spent during lifetime, or it can be spent after you die. Mm-hmm. So let's say the exemption comes back down to 7 million. You could either choose to make gifts during your lifetime of up to 7 million, and it would all be exempt, or you could die and then pass on 7 million, no questions asked. The opportunity that exists right now is that with the exemption at 12.9 million per person, if you're a couple and you're worth more than 7 million, you might consider capitalizing on this high level right now by making a gift to your spouse. And you can do this in both directions, husband to wife and wife to husband. And what you're doing is you're using up your federal exemption. But let's say you're worth 20 million. Right now, you can protect 25 million before you have an estate tax. So you might want to jump on this opportunity before 2026 to use up your exemption in the form of a lifetime gift in lieu of keeping it for later. And by doing that, you can, not only save a lot of tax money, but you're going to pass a lot more down to your kids. So for the wealthy, and when I'm thinking wealthy, I'm thinking, very wealthy, 10 million plus. This should be something in the back of your mind, and you don't want to wait until November of 2025, because there will be a lot of people doing this planning. It's called spousal lifetime access trusts, known as a SLAT.
So
you don't want to wait because it's going to be a very busy time period. So I would think start looking into this a little bit more in 2024. And if you want to pull the trigger, the first half of 2025 is a good idea.
Yeah, great, great advice. And I would encourage people to spread the word among your friends and relations that may be in that situation. But let me ask a simple question, as kind of a simple-minded question. You talked about this this special trust, this spousal lifetime access trust, as giving money to your spouse. Doesn't my spouse already own half my stuff? I mean, how's that work for me to give money to somebody that they've already got?
You have to do a little planning ahead of this. You have to basically divide up the money, and you have to, you can't, and it's not something you can do in a week. You gotta approach this with a little care. It is legal, no question about it. But you don't want to just make it painfully obvious you're splitting the assets one day and giving it to each other the next. That doesn't work well. But in effect, what you can do is you can split your assets. There is no limit on what spouses can transfer between one another. There's no tax of any sort. So it's a question of splitting up the assets and then giving a gift to each other.
And it's really just memorializing that and kind of putting it into a formal structure so that it's taken care of ahead of time, and it's very clear that we've used that exemption, used that credit during our lifetime.
Yeah, and I don't, I'm not trying to make it sound easy. It's not easy.
Yeah.
It's doable, but and it's definitely not something you want to try on your own. It's something where you need someone who knows what they're doing.
Yeah. Let's go back and talk about some of the other reasons that people might it might be prudent to update the estate plan. And you talked a little bit in a minute ago about moving from what we call a will-based plan to a trust-based plan. What are some of the reasons that somebody, you talked about maybe a younger couple kind of just getting started, a will-based plan might make a lot of sense. What are some of the reasons that that people should consider moving potentially to a trust-based plan? And we talked about the exemption amount, so there's a financial consideration. Certainly, that seems pretty obvious. What are some other reasons that might cause somebody to think about shifting to a trust-based plan?
We've talked a little bit about them. One is a blended family. You don't want to accidentally disinherit your children. Another reason might be if you start accumulating property in several different states. One of the downsides of a will-based plan is that you will end up likely going through probate at some point. And if you have real property in several different states, you're going to end up going through probate in each state where you own real property. Now, there are ways to get around this, such as putting the properties into an LLC. But, if you have several properties and you don't want to go through that hassle, having a trust and moving all the properties into your trust would avoid having to go through probate in each individual state. So that's one red flag I see often. Another red flag might be a special needs child. You often want a special needs child to inherit, an equal sum, but you have to be careful how they inherit, because if you just leave it to them outright, meaning they get the cash, then you run the risk of any government benefits being turned off while they have cash. Government turns around and says, you have some money now, spend it down again. If you ever need help, come back. But in the meantime, you have your own money, you don't need ours. Yeah.
Well, that also raises another issue that I think about, which is, again, we touched on this a minute ago, but as the kids grow up and grow out of the house and develop their own personalities, sometimes things happen in life. Sometimes, either there's maybe they get involved with somebody, a new spouse that maybe causes some concern, or maybe they develop some habits or some behaviors that cause concern too. And those may raise issues that may make sense to go back and think about a trust structure versus kind of the simple will-based structure. Is that right? Do you think about situations like that?
Yeah, no question. And this only increases as the sum of money gets bigger. Sometimes kids are just not good with money, and you want someone to be handling that money and doling it out to the child as needed, but not giving the child a windfall, because oftentimes a windfall can be dangerous. Money attracts the wrong crowd, and if your kid is hanging out with the wrong crowd to begin with, they can, in today's world, they do the wrong thing and they end up dead, overnight.
Yeah.
The other concern is, particularly with larger sums of money, is how the kids inherit. They can inherit outright, or they can inherit, such that a trustee is managing the income, and the trustee has absolute discretion when the kid gets the money.
Mm-hmm.
Or you can do something in the middle, where the trustee is managing the money, but the kids can demand it. Maybe they demand a third at age 25, and they demand another chunk at age 30, and they demand everything else at age 40. The beautiful thing about a trust is it's a lot more flexible than a will.
Mm-hmm.
A will typically says at the end of probate, distribute the money, collect receipts, give the receipts to the court, and then the court shuts everything down, probate's over. With a trust, you can have maybe a family member trustee or a third-party trustee. Oftentimes in a family, one or two children are just going to be difficult, and you don't want to name a family member because you don't want to put them in that awkward position. So you name a corporate trustee, a bank or a trust company, because they're not gonna know how to say no.
Yeah.
Which sometimes family members don't. So depending on the circumstances, at the end of the day, some kids should not be inheriting a big chunk of money. And the question is, how do you handle that? And typically you handle that with the trustee.
Yeah, that's a really good point. And one of the things that I think about as the use of independent trustees and a good time to update the estate plan, even if we've created a trust-based plan, but we've named certain individuals, family members, for example, to be the trustees. But as life goes on and life gets more complicated and personalities develop and potential conflicts develop, sometimes, a corporate trustee or an independent trustee can be completely appropriate for including in the trust. But the trust document has to recognize that, and that's got to be part of the plan. You can't decide. I suppose the trustee could decide, after the fact that they want to not be the trustee, and potentially, I suppose they would have the power to hire a corporate trustee, but that might get really complicated. So the right time back to you, when is the right time to really think about making those kinds of changes, and how should people be thinking about that?
Well, I mean, if you want your children to inherit in trust for any of a number of reasons, now is the time to be thinking about that. I mean, my business simply comes down to planning. It's all about planning ahead. And I'm one of those people who believes in planning ahead. I mean, things change. And you go into war, and the fog of war changes things, and then your plan is not so good. But, it's better to have a plan than to not have a plan, in my opinion.
Yeah.
So the time is now. I mean, you should be thinking, if do my children, should they inherit in trust? Should they inherit outright? If they should inherit in trust, do we want to have a family member? Or is a corporate trustee a better option?
Mhm.
You know, that's the type of thing we would go over. If you're looking at a trust, one of the basic questions is who's going to be the trustee,
Yeah.
and who's going to be the backup if that trustee is unavailable.
Yep.
One of the nice things about corporate trustees is they typically don't die on us. So if
Right.
you name a person and that person becomes ill or is otherwise incapable of fulfilling the role of trustee, you're always going to have a backup, but the backup is number two for a reason. They might not be the best person. So, that having a corporate is not a bad idea in many cases.
Where it's appropriate, we really like the inclusion and using independent trustees, corporate trustees, where it makes a lot of sense, because it can remove so much emotion and family tension from the situation. I think a lot of times people are maybe afraid of that or skeptical about appointing an independent trustee or a what's called a corporate trustee. But I think it can just make so much sense for a lot of folks. And as you know, we like working with the bifurcated approach where we like having an independent trustee, corporate trustee, that simply does trust administration, and then the trustee or whoever manages the money can be a separate entity. Sometimes, at least in our thinking, there can be a conflict of interest if the trust company is also managing the money. But that's kind of our approach, and not something that Vermont has adopted the way a lot of states have adopted that approach necessarily. But
well, one of the nice things about having that approach is that you don't lose your connection to your financial advisor.
yeah,
I mean, you worked on this connection, you've developed it, it's grown and it's blossomed, and now you don't want to just turn that over to someone else. I mean, it just makes sense to stay in the path that you're on.
yeah, we certainly think so. Grandchildren. So a lot of times in life, if we're doing our job right as parents, we have kids and we get our will in place, get our basic estate plan in place, but we may not have allowed for or made provision for a new generation coming along, and as we live our lives, sometimes that next generation comes along and we have grandchildren, and they may want to play a role, or we may want them to play a role in our estate plan, or what I mean is be beneficiaries of our estate in the long run. So how might the estate plan change with grandchildren now in the picture? What are some of the things that people might want to consider as they're thinking about kind of that next lineage within the family structure?
Well, most of my clients, if they leave something to the grandchildren, it's usually a nominal amount. It's not like 25% of the estate, something crazy. So, and that's typically my advice. My advice is give it to the children, your children, and then let them decide how the grandchildren are going to inherit. But there's a side issue going on here that people are, need to be aware of. And I've read statistics along the lines of 55% of grandparents are now helping their grandchildren pay for college.
Yeah.
And what you should know is there is a gift tax, a tax on making gifts, but there's a $17,000 limit. If you're under $17,000 per person in any given calendar year, there's no tax. If you give more than $17,000, then you're deducting the amount above $17,000 from your federal exemption amount. But you should know that if you pay someone's tuition, there's no limit on what you can pay.
Yeah.
So there's no $17,000. So I don't want to run out and say, everyone should give to the grandchildren's education because it's hugely expensive. But the sad reality is education has gotten so expensive that grandparents are being approached, more than half of grandparents are being approached, say, can you help? So, it's a big deal. So when I think of grandchildren, I think more of helping them. Not all grandchildren need to go to college, but for those who want to, I think of grandparents helping out in that regard really
Yeah.
more than anything.
Yeah. It's such a good point, and we really try to educate people about how the tax code works in that way, that while I can give a gift outright, but it does use my exemption above the $17,000 annual limit. I can write the check directly to the college and it doesn't count. I can if that bill, and I have the wherewithal, if that bill's $45,000 for this year, and I want to pay it for my grandkids, that's a much smarter way to transfer assets to the next generation in a way ahead of time, than trying to worry about an outright gift. So.
Right, and on top of that, if your grandchildren are young, look at a 529 plan.
Yes.
And talk to your financial advisor about how to structure that. There's been some interesting changes in the 529 plans, and it's definitely something you should be looking at.
Absolutely. Yep. We now have the small ability to transfer some of those older 529 assets to Roth for the beneficiary. So those are some interesting nuances that have just come along, actually just at the end of last year. So Secure 2.0. Adam, when you're working with clients on kind of the initial estate planning process, you must be aware, and you must prepare people for the opportunity that there's going to be an update to the estate plan at some point down the road. How do you prepare them for dealing with updates down the road? How do you make sure that they're not thinking about it, in other words, as a one and done deal? How do you get people thinking that way?
So my thinking has changed on this. I used to offer a plan that people could pay an annual fee for, and I would give them certain services every year, so long as they paid that fee.
Mm-hmm.
But my thinking was the value was there, but people weren't taking advantage of it.
Mm-hmm.
So I felt like I was charging people, and they weren't even coming back and doing anything. So
Yeah.
I gave up on charging people, and now I say simply, clients get a free annual meeting. Every calendar year, you can come in and meet with me once at no cost, and we do three things. We walk through the people, because the people in your plan, because again, the people are most likely to spur a change.
Mm-hmm.
We walk through your plan because plans can be complex. Trust-based plans particularly are complex, and people forget how it works. And so I want to refresh them on how it works. And then we walk through the finances to walk through each account, every financial account, every insurance policy, to make sure that we are handling that asset correctly, so that
Mm-hmm.
we're not going to be blindsided later by some assets that were just overlooked. And in the course of that meeting, I'm reminding people, you might think about this, or you might be thinking about that. So my plan for getting people to be thinking about updating their plan is simply to come in once every year if they choose to, but most people come in every 2 or 3 years. And I'm trying to reduce the barriers to that happening by making it free, because I want people to be, when the time comes, I want the plan to be what that person wanted. I don't want to be working with a 20-year-old plan, because honestly, for my own well-being, I don't want a bunch of angry children looking at me and saying, why didn't you fix this?
Yeah.
I want the plan to work. I want the plan to work well. It's never going to be perfect, but I want it to be a good, solid plan that reflects the wishes of the decedent.
Yep. That's great. And I love your approach, Adam, because I think you're right. If we can, we have a kind of a similar thought process. If we can remove the barrier of people thinking, the clock's ticking and we're gonna charge for every minute that we talk to them, then maybe they'll come and have the conversation when it's top of mind and when it's important to have the conversation. We've got a question from the audience, which I think is absolutely relevant and has to do with this whole topic of, is it time to update the estate plan? And they ask if we have an existing living trust, but they set it up with another attorney and maybe it's some time ago. What's your process of reviewing kind of an existing trust? And do you simply edit the existing trust, or do you start over, or what's that conversation? What's that process like? In other words, somebody has a plan they created some years ago, but either that the original attorney's passed away, or there's not the relationship there, or whatever.
Yeah, I'm glad this question was asked, because I'm presented with this situation all the time.
Yeah.
People want me to review their trust, and I'm happy to do that. I'll give feedback on the trust. However, I do not amend another attorney's work. And the simple reason for that is it would take me more, it's more cost effective for me to start fresh. If you don't, basically, it's a difficult situation, because people come to me and they say, oh, I just need this done. But if I review that trust and then I just make that simple fix, I'm effectively responsible for the entire trust.
Yeah.
If something goes wrong in 3 years, your children or your spouse is going to look at me and say, but you reviewed this trust. Why didn't you see this? Now, for me to review a trust line by line is a time-consuming endeavor. So I will look at it and give you general feedback, and I will give you my thoughts on the trust, but I'm not going to hold myself responsible for some other attorney's work. So if you want to have it updated or redone, I'm going to, unfortunately, I'm just going to start fresh, and it's going to be as though you're starting over.
Yeah.
So that's not good news to a lot of people, but again, I have to be careful about what I agree to and what I don't agree to, and taking on that responsibility is just something I can't do.
I appreciate it and think it's entirely appropriate, Adam. I was chuckling a little bit thinking about the kind of the doctor analogy that you used before, and thinking, if you're a surgeon and somebody comes to you and said, I had my appendix removed 5 years ago from this other surgeon, and it still kind of hurts. I want you to just go in and just, I think one of the sutures is stuck in there. Just go take that out. Yeah, you're probably not going to take that approach, right?
Well, the analogy in the estate planning field is basketball.
Yeah.
It doesn't, whoever touches the ball last before it goes out of bounds is the one who is responsible.
Yeah.
It doesn't matter if it just bounced off your knee or if it bounced off your hands. Whoever touched it last is going to be held accountable for the ball going out of bounds.
Yeah.
Same thing with attorneys. If you reviewed that trust, people are going to think that you okayed it.
Yeah. And unfortunately, that it's just a reality that there's a cost to that. There's a cost to your time, to and everything that you've invested in your education and your expertise and your practice to put that together. But when we think about the potential expense to the estate and to emotions and anxiety and conflicts and other things, those costs are minor at the end of the day, and just part of taking care of things and being a responsible adult in a way, I think.
Yeah, I mean, I'm not cheap, so I'm not going to say it's insignificant, but if the trust is old, I would have it looked at. I mean, I'm happy to look at someone's trust and give you my general feedback. It's just a difficult position to be in, to be perfectly honest. But I do agree, if you have questions and it's keeping you up at night, there's value in sleeping well.
Yeah.
And if that includes redoing your estate plan, there's value in sleeping well. So I would think it's worth the money.
Yeah. Well, and especially, when we talk about these old plans that truly have the potential for disinheriting, spouses unintentionally, that can really be a problem to avoid.
Yeah, we always draft plans based on the existing law. So, and the law changes. And 15 years ago, the law was quite different than it is now. So there's a good chance your trust is fine, but there might be things in there that are going to be unfortunate when the time comes.
Yeah. Let's talk about families and communication, because, some of the things that we've talked about is removing beneficiaries or updating kind of how the trust will be distributed in time. And how do you counsel people, and what are your thoughts about conversations with the family, potential conversations with beneficiaries about the structure of the estate plan? I mean, that can be a fairly dicey situation. I know from experience, clients have a lot of emotion about that, and sometimes they think, yeah, we're going to get everybody together and have a conversation about it, and sometimes it's like, no, not so much. That's kind of our business. What's been your experience, and what are your thoughts about involving the family in the estate plan? And maybe it's an updated estate plan and there's changes. How do you think about that?
Well, my general thinking is the fewer surprises, the better. So if you are comfortable talking to your children about your estate plan, I would say go for it. It's a good idea because you want them to understand, in general terms, what's coming down the pike. But if you're not comfortable talking to them, then let's not open up a can of worms. I mean, we don't need to go there. It's your plan, it's your money, it's your decision, and it's going to play out according to your wishes. But on the other hand, if you are comfortable, I offer this free annual meeting, and if people want to have a family meeting in lieu of an annual meeting, they can bring in their children, and I will talk to the parents ahead of time and say, okay, what do you want to cover and what don't you want to cover? And then we'll walk through the plan. Not a lot of people have taken me up on that, but I think it's a good option for some people.
And do you ever? I'm sorry, my mind went somewhere else. So thanks for addressing that. I think it's a really good idea. If, like you said, I kind of follow your philosophy as well. If people are comfortable having those conversations or are used to having those conversations, then go for it. But otherwise, it's nobody's business, and you don't have to. And I also sometimes offer to be a part of that conversation if it helps. Sometimes having a third party, such as yourself or such as the financial advisor, can help communicate that and can help express the parents' view. What are your thoughts about that?
I very much agree. I mean, I mentioned how people forget how their plans work. What you really don't want is, miscommunication.
Yes.
Creating conflict that's totally unnecessary.
Yeah.
So if I can take a part in that role and explain exactly how things are going to work, or how things are supposed to work, I'm happy to do so, because people, everyone's a little different, and everyone thinks a little differently, and everyone hears a little differently. So, what I say might be heard by 3 different people in different ways, and they can take 3 different things out of it. So if I can contribute to a more solid foundation for the children or whoever it is to understand what's going on and what the plan is, I'm happy to do so.
Yeah, I really support that. And I'm thinking about some of the flow charts that we end up with at the end of the estate plan. And sometimes I think it's better to have, the originator or people that understand it explain it, because clients sometimes don't fully understand it, and it might create problems. We've got a question. I know, Adam, that you are you practice in Vermont, but also can practice are a member of the bar in Massachusetts and I think New York too. What do clients do if they live in another state and they come to you? How do you handle that? And by the way, correct me if I'm wrong. You still work with clients that have Massachusetts or New York as well as Vermont. Is that correct?
I do, just not as deeply as I do with Vermont clients. For example, I do trusts and I do wills in both Massachusetts and New York. Mm-hmm. I typically have an attorney in those states review the plan just to be sure that everything's up to speed. But I don't do deeds in other states, and I don't do probate in New York and Mass. Mm-hmm. Those are more local based, and I just don't know the system that well. Mm-hmm. But yes, I do planning. But as I said, I typically involve a in-state attorney to confirm that I've done everything correctly. Mm-hmm. Because being legal in a state and knowing how to do it correctly are two different things.
Yeah, and if they let's say they live in Colorado or Ohio, or a state that you're not a member of the bar, but they approach you and want to work with you, do you just kind of throw up your hands? You can't help them, or do you, like you said with Massachusetts and New York, do you get a local attorney involved and kind of act as a quarterback?
On occasion, I might do what's called co-counseling, which mm-hmm. is where they have their local attorney, and if they prefer to work with me, I could do the plan. And then the local attorney is gonna approve it and take responsibility for the in-state issues, so to speak. Mm-hmm. It's not a whole lot different than my process for New York or Mass. Mm-hmm. But honestly, I do believe, unless it's someone who's coming to me for a really good reason, I would encourage most people to find an attorney in their state of residence and develop that relationship. There's value in that. Yeah. And sometimes people might want to work with me for a particular reason, but I can usually point you out to very good attorneys in different states because I'm a member of different organizations, and I know very good attorneys in those states. So honestly, I'm so busy. I'm happy to pass people. If someone's from Colorado, I'm happy to find a Colorado attorney because I really think that makes more sense.
Yeah. And we're reaching the end of our time. I know you are busy, Adam, and we're glad that you are. We love referring clients where it makes sense to you, and enjoy your collaborative approach to working with us and others. But just to set expectations, you're a pretty busy guy. If somebody is new and on the call today and they want to meet with you, are you accepting new clients?
I am. What I'm doing right now is I'm happy to meet with someone and to talk through the issues and to give the potential client a chance to decide if they want to work with me. Mm-hmm. If they decide they want to move forward, then I'm saying it's not going to be until middle of May. Mm-hmm. So I'm happy to have that first meeting, but I'm about 2 months out at this point, so I'm looking to lessen that, but it takes time.
Well, we're glad that you're busy because you do great work for our clients, and we really appreciate that. So we're just about at the top of the hour. We've gotten some questions from the audience. We appreciate that. If people have follow-up questions or anything else that they want to send to us, we encourage you to send it to us directly at Copperleaf, and we can certainly forward it on to Adam, or we may be able to answer the question, but we're happy to get you in touch with Adam. And I guess, Adam, how would people reach you directly if they want to get in touch with you?
Well, they can either give me a call, 802-985-8811, mm-hmm. Or they can simply go to my website, neetlaw, NEETLAW.com. Mm-hmm. And if you want to set up a meeting, actually there's a little application called Calendly on the website at the bottom of the main page. And you can schedule a meeting. You can look at my schedule and set up a meeting, or you're welcome to call me. And certainly you can reach out to Michael and get my contact information through him.
Right.
Any of those avenues.
Great. Thank you, Adam, for participating today. We hope everybody got a lot of good information about this, and I think I hope people follow up, and if it's time for them to update their estate plan, they'll understand good reasons to do it and kind of what the process is. Join us next month. Next month, we are going to be talking about private foundations and when it makes sense, it may make sense to establish a private foundation and how foundations work. So we're looking forward to talking about that next month. And in the meantime, happy March, everybody. I hope you're not getting snowed in too much, and you enjoy the rest of your day and the rest of your month. And thanks a million for joining us. Bye, everyone.